Welcome to Video 2 on the Mine Health and Safety Act, focusing on legal liability. Section 23 of the MHSA addresses an employee's right to refuse dangerous work and subsequent employer obligations. This includes notifying other employees of a refusal. If no health and safety committee exists, consultation must occur with representatives or employees. An employee who refuses work in good faith cannot be disciplined and is entitled to full wages and benefits. The employer may temporarily reassign the employee to alternate work while the situation is remedied, but the employee must remain at the workplace during normal hours unless given permission to leave. Dangerous work involves safety and health risks beyond the job's normal scope. The employer must, in consultation with the Health and Safety Committee, establish procedures for dealing with a refusal to work in dangerous conditions. If no procedures exist, the employer should follow a sequence of steps. Step 1 involves the worker immediately reporting the refusal and reasons to a supervisor and the health and safety representative, who must attempt to resolve the concern. If the employer satisfies the employee's concern, the employee returns to work. Otherwise, they proceed to Step 2. If the parties cannot resolve the refusal, Step 2 requires management and employee representatives to inspect the workplace. If the dangerous condition remains after inspection, they must continue to Step 3. In Step 3, any person present during the Step 2 inspection may notify a safety and health officer. The officer will investigate whether the refusal constitutes a danger. The employer has the right to ask the employee to remain at a safe location, do other work, or assign alternate work to affected employees during this investigation. The employer can only assign another person to perform the refused job if the other employee is qualified, informed of the refusal and reasons, and the employer is satisfied that the other employee will not be put in danger. The MHSA mandates a health and safety management system to ensure a safe workplace and mine environment. Sections 2 and 5 require the employer to develop and maintain an integrated system covering all operational aspects. This compliance system must include legal assignments, employee consultation and participation, and risk assessments. A comprehensive compliance system should also encompass training and induction programs, project, change and purchasing management, occupational health programs, engineering and maintenance, safe work procedures, emergency procedures, supervision, communication, and incident management. Legal appointments or assignments are common law delegations of power and must comply with common law principles to be lawful. Delegation is the act of turning over the exercise of certain vested powers, in full or in part, to another authority. The delegate's powers are exactly those of the delegant, and delegation is a transfer of power, not just permission. Delegation occurs when people ask others to perform tasks on their behalf and is beneficial for overcoming personal limitations. However, a great danger is the abuse of delegated power. The delegation of powers and functions is subject to principles of administrative law. A checklist for delegates includes ensuring the decision-maker has jurisdiction, the decision is authorized by the enactment, required procedures are observed, and the decision is not an improper exercise of power. Improper exercise of power examples are irrelevant considerations or the power being used for an unintended purpose. Additional checklist points for delegates include ensuring the discretionary power was not exercised at the direction of another or without regard to the case's merits. There must be evidence to justify the decision, and it must not be affected by fraud or involve an error of law. The decision must comply with natural justice and not otherwise be contrary to law. An appointment or delegation does not automatically make the appointee accountable solely in that capacity. Any person contravening the legislation can be criminally liable, regardless of their appointment status. An appointee is only liable for failing to perform a duty imposed by their appointment, provided they receive the necessary training and assistance. The principle of control means a person who takes charge of responsibility and issues lawful instruction may be held accountable for the consequences, even without a signed letter of appointment. This legal principle dictates that assuming control of a situation also assumes liability for the consequences of that control. The elements of control include that which checks, restrains, or hinders. It also includes the power or authority to check or restrain, or to exercise a governing influence. Control can refer to the complete apparatus used to manage a mechanism or machine in operation. Delegation of functions and responsibilities is carried out through letters of appointment. Key elements to include in these letters are the employer's name, the name and designation of the person making the appointment, and the name and designation of the person being appointed. The letter of appointment should clearly identify the appointee's area of responsibility, stipulate their duties, and indicate the name or designation of the person they must report to. Additional requirements for the letter include indicating the period of validity, which means the date of commencement and termination, and the signatures of both parties. It is crucial for the employer to provide letters of appointment that align with these key elements to limit their legal liability. When appointing a person, the employer must ensure the person making the appointment has the necessary authority and is confident that the appointee is competent for the specific functions and duties assigned. The employer must also ensure the appointee is not overburdened with excessive duties. The appointee must be fully aware of their responsibilities, scope of authority, and the legal liability for noncompliance. Only current and applicable legislation should be mentioned in the letter of appointment, and repealed legislation should be deleted. The person delegating responsibilities must take reasonable measures to ensure the appointee complies, as the delegator still retains a supervisory function. Importantly, delegation does not relieve the employer of any accountability under the MHSA. Specific legal provisions in the MHSA dealing with legal appointments begin with the Chief Executive Officer. Section 2A1 requires the CEO to take reasonable steps to ensure the employer's functions under the Act are properly performed. The CEO may entrust any function under Section 2A1 to any person under their control, but this does not remove the CEO's responsibility. If the employer is a body corporate, the board may designate a member to perform the CEO's functions under the Act. Subsections 1, 2, and 3 do not relieve the employer of any duty imposed by the Act. Every person appointed under Section 3 or 4.1 must perform their functions subject to the control and direction of the CEO or the designated board member. Section 2A3 allows a mining company's board to nominate a person, other than the CEO or executive chairman, as the person with ultimate authority for the Act's purposes. Section 2A4 adopts the principle of vicarious liability into the Act. Regarding the mine manager, Section 3.1 requires the employer of every working mine to appoint one or more qualified managers for day-to-day management, ensure their functions don't overlap, provide them with the means to perform functions, and take reasonable steps to ensure they perform those functions. The appointment of a manager does not relieve the employer of any duty. If no manager is appointed, the employer must perform the functions of a manager. The ultimate responsibility has shifted from the mine manager to the employer and their representatives. To address the shift in responsibility, Section 7.2 is often used to delegate all duties, except those in Sections 2 and 3, to a mine manager. This delegation typically includes normal mining activities like employee induction, risk assessment, and medical surveillance programs. Section 4.1 permits an employer to appoint any person, except a manager, to perform functions entrusted by Sections 2 and 3. The employer must notify the Chief Inspector of Mines of this appointment within 7 days, including details about the appointee, their functions, and managers under their control. The employer must provide appointees under Section 4.1 with the means and take reasonable steps to ensure they perform their functions. This provision is intended for head office-based consultants or site-based project engineers who provide services to the mine. The employer may appoint any person to assist the manager in performing functions and to assume accountability. This assistance includes legal accountability for the performance of a designated portion of the manager's duties. This provision clarifies that the employer is responsible for appointing competent people to assist the manager and for ensuring their functions don't overlap. It also requires the employer to provide the means for these appointees to perform their duties and to take reasonable steps to ensure compliance. The appointment of an assistant manager does not relieve the manager of any duty. If no assistant manager is appointed, the manager must perform the functions of an assistant manager. The employer must provide all employees with health and safety training as far as reasonably practicable. This training must ensure employees are properly trained to deal with risks associated with their work. Training should cover measures to eliminate, control, and minimize health or safety risks, the procedures to be followed for their work, and relevant emergency procedures. The employer is obligated to ensure this training is provided. This training must be provided before an employee first starts work and at intervals determined by the employer in consultation with the Health and Safety Committee. Training is also required before significant changes are introduced to procedures, layouts, methods, plant, equipment, material, or the nature of an employee's occupation or work. Training is a learning process that involves acquiring knowledge, sharpening skills, and changing attitudes or behaviors to enhance employee performance. It is an activity that leads to skilled behavior, and it can be formal or informal. Informal training includes on-the-job training. While often used as the only form of training, on-the-job training should be a part of a well-coordinated training program, not a substitute for a developed program. Formal training includes lectures, used for their low cost and ability to reach many people. However, lectures, which are one-way communication, are often criticized as a training device. Possible types of training include employee orientation, which is crucial for new employees, teaching company goals and how they can contribute. In-house training upgrades the skills of current employees, helping them adjust to changes in job requirements, and is often best offered by a supervisor. Mentoring is a specific type of in-house training where a high-rated employee teaches skills to another. External training involves sending employees to seminars, courses, or workshops.